UAM TV, right on. It's Wednesday, and welcome back to Speaker Therese Terlaje for our standing Wednesday appointment with the Speaker. Good morning, Speaker.
Good morning. Good morning, everyone at KUAM, and good morning to the people of Guam.
Right on. Let's just get right into it, Madam Speaker. I know that session, and then there's also a hearing tonight on Bill 112, so go ahead.
Yeah, so we've got so many things going on. So first of all, our session for this month will begin on Friday at 10 a.m. We are right now on our agenda 7 bills. One is relative to eliminating the requirement that any deed or instrument conveying registered land in trust upon condition or upon limitation contain the words with power of sale in order to empower the trustee or transferee or such registered land to deal with the same without court order. We've also got Bill number 99, which is relative to granting indigent inmates the ability to acquire their constitutional right to legal representation. This is regarding the phone calls that they can make from prison and funding of that. There's a Bill 108, which is relative to streamlining adoption policies and procedures. There's Bill 109, which is relative to the inclusion of adoption agencies in the chain of custody for infants relinquished under the Newborn Infant Safe Haven Act, and other things that that bill does. There's Bill 134, which is relative to removing the minimum acreage for protection of farms. There's a Bill 136, which is relative to the preservation and disposition of court records. There's Bill 121, which is relative to the design, build, finance, lease, transfer, and maintenance of Government of Guam 21st Century Healthcare Center of Excellence, which shall be called the 21st Century Healthcare Center of Excellence Construction Act of 2021. This is the bill that allocates earned income tax credit reimbursements towards the building of the new hospital and healthcare centers, including public health. So those are the 7 bills currently on the agenda. At the rules meeting, I also announced that if I can get this bill routed in time, and I'm also going to try to put on Bill 36-36, which is the leasing of a corridor in Alupang to GTA for a submerged cable. And there were other bills that were also, I know that senators are trying to route as well in time for session in order to try to place those on the agenda. And those will all be done by motion.
Okay.
And so on Monday, so our session will continue next week, throughout the week. We'll probably vote on Friday, but on Monday, we're also going to be welcoming the Congressman, Sir Nicholas, to give his congressional address. And so we're looking forward to that. That's at 10 a.m. on Monday.
10 a.m. Monday.
And so today, yeah, we have also a full slate just for today. I've got 3 sets of hearings. One is we're confirming members to this Criminal Injuries Compensation Commission. One of them is Denise Mendiola, Dr. Lisa Flores, and also the former Attorney General herself, Elizabeth Barrett Anderson, has agreed to serve as a member of this Criminal Injuries Compensation Commission. She's one of the people who really reactivated and made this commission very proactive, I think, and in compensating victims of crime. That's at 9 a.m. this morning. At 2 p.m., we're having an oversight hearing of the Chamorro Land Trust, and I've narrowed it down to 2 issues, which really are to me, the most important issues that this trust should be dealing with, and that is residential lease applicants and agricultural lease applicants that have been on the waiting list since 1995. What is the status? Are I've been receiving calls that they're being told they got to do all kinds of runaround to reconfirm their eligibility. And I have discussed this with the Chamorro Land Trust, and I think that's wrong. I think that the Chamorro Land Trust should be able to confirm their eligibility. The new law was supposed to expand eligibility to more people, not to, remove people from the eligibility list. So I just feel like that's something I really want to address in this hearing today, and make sure that we are taking care of these people who have been waiting since 1995 on this waiting list. And the way we're going to take care of them is by hooking them up with land. And so that's the second part of the hearing, which is the inventory of the properties that are still in need of surveying, registration, and that if they can identify for us which of these properties are still in need of infrastructure, especially including water. That's really been, to me, the detriment, the holdback, the big barrier for people to, in this affordable housing that we thought the Guam Chamorro Land Trust was going to provide. This has really been a barrier. They've not been able to get the property, or they get property that's not really very well divided. They're not able to bring infrastructure in. And so we've tried in our American Rescue Plan Fund, or the, our plans that we submitted to the governor, we are suggesting that they put money to GWA and to the Chamorro Land Trust to ensure that these properties are surveyed, that the infrastructure is brought out to those areas. And this will not only affect Chamorro Land Trust lands, but also all the surrounding areas. It will hopefully allow businesses to thrive in the area, and it will allow, at a much lesser cost, Chamorro Land Trust recipients to hook up to that water supply. So we're really looking forward to some of those funds being allocated. But before that can be done, and if it's going to be done, if we're going to be able to use those funds in time, the Chamorro Land Trust really has to, have their act together. They've really got to have a good handle on their inventory. They've got to know where the priority tracts, huge tracts of land are that we can take care of these applicants on. And we've seen a lot of the meetings lately, they're talking about commercial leases. Well, there's the law on commercial leases says that you're supposed to proclaim that this land is not necessary for residential or agricultural leases. And I just want to confirm this through today's hearing as well, because all this priority on commercial leases, while we have 8,000 people waiting on a waiting list, is kind of baffling for me still, right? How can you declare land available when you've got 8,000 people who are not hooked up to a certain parcel of property? So I want them to get hooked up, to link the inventory and the people on the waiting list. And then we can very, I think, comfortably declare that we have property that's not necessary for residential or agricultural leasing. So that's the point of the hearing today. And I think these topics are really going to entail almost everything that the commission does. So that might be a long hearing. Yeah. I know my colleagues have many questions that they want to ask.
Yeah, and sorry, man, it's just because the questions are piling up. So again, we had Senator Joanne Brown on yesterday. She brought up the whole Jack Hattig executive session issue that she had been asking for you to have an oversight hearing on it. So I guess our question is, are these topics going to be covered tonight, or could you address why we didn't see them in the agenda?
Well, I think that they are relative to applicants for residential leases. That's exactly what was going on at the time. They were trying to address applicants or their, particular issues with these applicants. And I think that, we provided the response from the Chamorro Land Trust Commission that they only found 2 cases where that activity, where the agents' recommendations were changed. So far, they've only found 2. And so they're able to, I'm sure they will be able to answer any questions on that. But I think the more important part is that there was an allegation by the senator that there was forgery. And that's a criminal allegation. And I have referred that to the Attorney General, not for an opinion, but for a prosecution if that is truly what they find. So I am confident that, we put it in front of the Attorney General's office, who is the person to prosecute crime, and that if it is a crime, that they will address it.
Thank you. Also, just going back to what you had said about in you guys' spending plan, you did note down there that there was a certain amount of money from the ARP that you guys wanted to go to GWA to stave off a potential rate increase that was going to be implemented over 3 years. And then also, I think that was the one. And then also money to Chamorro Land Trust. That being said, you guys had the big meeting with the governor. Have we heard anything from Adelup on the legislature's spend plan that was submitted to her for the American Rescue Plan funds?
No, we have not formally, especially not me, and not formally. And so, we tried during our budget hearings, we continually ask them what are their discussions regarding ARP, what parts of their agenda for FY22 are they planning to fund with ARP money, so that we can have a good idea as to what is going to be taken care of in FY22. So it's very clear to me that the agencies have made requests to the governors. I've tried to FOIA those. I think you have as well. And so far, I've not gotten any responses, but I'm not giving up on that. And now that the governor submitted something to the Treasury, I want to thank you for your FOIA on that, and I'd like to see that too. We have not received a copy of that as well.
Okay.
So I just think we need to work together on this because we've got a budget to take care of the people of Guam. And if we are going to take care of them in the right way, then we've got to know what other resources are being allocated so that we don't double allocate and that we don't shortchange anyone who's not going to be getting anything from this ARP, the shortchange of services. And I think that's really what we need to take care of. And if we have money available for, additional, expanded relief, then I say, let's use it. And so, we've got quite a bit of money coming in. In addition to the ARP, we're going to be getting earned income tax reimbursements. That by itself is such a huge amount of money, and it would have completely changed how, we do our budgets because it's such a large amount of money. Same thing with the child tax credits. We're going to be reimbursed child tax credits. That's, again, a huge amount of money. And so we've got so many things that really Guam should really be progressing in the next few years. And I want to ensure that we do our due diligence during budget proceedings and passing this budget, that we don't close our eyes and we don't wish, and that we actually, try to force some real disclosure and real transparency.
Man, closing our eyes and wishing is just so much easier, though. But Speaker, you mentioned my FOIA, and I did want to just share with the audience because we didn't really do anything on this. So I did send a FOIA to the Office of the Governor, and it was for all documents relative to correspondence between GovGuam agencies and the Office of the Governor regarding requests for American Rescue Plan Act funding. And so what I was trying to get, I also had sent a FOIA for anything they had sent to Treasury, which they didn't honor or grant, or what they denied. Anyway, so I had sent this FOIA to Antelope, and they first asked for an extension to 10 days, which, I mean, usually when they ask for an extension, you're thinking, all right, I'm going to get something because they got to get everything together. Then after 10 days, they responded and denied my request and said, please be advised these documents were submitted to assist Governor Leon Guerrero in making substantive decisions related to the allocation of federal funding provided under the American Rescue Plan. As such, they are subject to a disclosure exception known as the deliberative process privilege. C5 GCA, United States Fish and Wildlife Service et al. Versus Sierra Club. I never heard of that disclosure exception. But yeah, so we did try and get the information, because what we're hearing, Senator, and there's got to be paperwork on this, because you're getting these agency directors that go into the legislature and they're saying like, oh yeah, we're going to get 20 million, or some of them like Chief Stone are acting like it's a top secret issue. Like, oh, I can't tell you how much we're going to get. So we know there's some kind of correspondence, and I don't understand why they're just not being forthright.
And it's actually, I think, very alarming that we are going to communicate with the federal government, and that we, the people of Guam, are not going to know what those communications are. I think, I've never seen that. I've never heard of it. And yes, I've heard of that exemption from FOIA. However, that was really discouraged in the last presidential administration, where the Department of Justice came out and told agencies, if you're going to claim this, we're not going to defend you unless you do this, this, and this, and this. And they really wanted to ensure that they weren't abusing that exemption, because, it controverts the spirit of the, open government information to people who are really going to be affected by the use of this money. So I think it's fair, whether they can, stick by that exemption or not. I still think it's fair that the information be provided to the people of Guam. And I think for it not to be provided to the legislature is going to hinder our ability to really hone in on this budget and get it done in an efficient and fair way. We're talking about services to the people, and that's the bottom line. I think we should all know what's going to be planned.
It's kind of just also mind-boggling to me, because they did it with the CARES Act. They came out with a proposed, spend plan for the CARES Act, and they're not doing it with the ERP. I wanted to ask, though, just real quick, because I know we're going on to this Bill 112 hearing, Madam Speaker, but what was your take? We had the CNMI governor's office spokesman on last week, and they've already started spending their American Rescue Plan funding. They've given $400,000 to a cancer nonprofit to continue essential cancer treatment services. They've also, I believe, their governor is rolling out a direct assistance, which is supposed to hit within the first couple weeks of July. So while our governor is sitting on this 600 million and saying that you can't touch a dime of it until they have the final guidance in mid-July, our neighbors 45 minutes to the north have already begun putting this money in the hands of the people. So just kind of what's your take on this tale of two islands?
Well, I think we talked about this before, and I told you I wrote a letter to the governor encouraging her to pay that RISE Act direct relief out right away. I guess I can't see the rationale. It's very clearly within the scope of the ARP guidelines, and I don't think that that's going to change. And so I think it should be done. And especially if they're having people go through a process of submitting applications, then they should start that right away. I asked Daphne at the last hearing, the Director of Revenue and Taxation, whether that's really necessary. Do they really have a legal basis to requiring that? Or can we can we waive that requirement that people give the Department of Revenue and Taxation some type of authority to give us our refund, or to give us, the relief, And so I hope that if she can find nothing in writing, that they just say that that's not necessary and that we are able to change that right away. But anyways, no, I agree. I agree that if the jurisdictions are clearly able to use the money, and that the use of this money for direct relief to people affected by COVID is very clearly within the guidelines that it should be done. That one's clear to me. There are some that may be debatable, but there are just some things that are not debatable under these guidelines, under this law.
Okay.
And I think the governor agreed that this would be an approved use of the funds. So, yeah.
And it's a law too. Oh, I forgot it's a law. Yeah, that's kind of the big cherry.
Since December, yes. Yeah. And I feel for the people. They're really in need of this. So they continue to call our office asking about it. They are in need of it, and I haven't seen otherwise. We've seen some businesses on Guam are really thriving. Some businesses have never, faced a shortcoming during this pandemic, but many have. But more importantly, I think many families have. And so, especially while we are raising the moratorium on evictions, this is critical. And we've seen very little relief granted on the rental relief. So I just think if they can use it to keep their families afloat, then let's just get that out right away.
All right, thank you for that. Now on to this hearing tonight. You're introducing Bill 112, which has definitely made a lot of waves before it was even introduced.
Yeah, well, we had, since last term, we took it upon ourselves to have 3 informational briefings. These were huge. It was the first time the medical malpractice law had been, looked at again in like 30 years. So we looked at it. We asked for all kinds of suggestions. We heard from many, many doctors. We heard from patients, and we've heard from, lawyers. We heard from all sectors of the community, and we tried to combine all of that testimony. And I thought it was clear that everyone acknowledged that there was an issue, that arbitration, as mandated under current law, is so expensive that it precludes not just the indigent, poor people, but the working class people from even beginning the process, which requires a $10,000 filing fee, right? On top of that, you pay arbitrators' fees at the rate of $450 an hour, their travel sometimes, their rooms, for the adjudication, all kinds of costs. And so the average that we were told is about $50,000 to get through arbitration. And that's only to allow you to go to trial. So we've given doctors by law, because of our policy that we need doctors, we want to attract them here, and we want to, retain them. We've given them a very special protection. So my bill 112, does not repeal special protection for doctors. And I think that that needs to be made very, very, very clear, because there's a huge misconception out there that now they're going to be exposed to all kinds of liability that they weren't exposed to today. And that's absolutely wrong. The standard of care that we've put in our bill, we copied from the current law. So we are continuing the standard of care. And that means if what you are doing is not malpractice today, it is not malpractice tomorrow. It's exactly the same standard of care. And if, our standard of care is based on our community, of course, and so it's unique to Guam. And all cases will be judged that way. And so what the bill does is really, it allows arbitration to continue, but it doesn't mandate it, and it doesn't mandate that costly arbitration procedure. It allows the patients and the doctors who are in the proceedings to come to an agreement as to arbitration, to come to an agreement like every other case on Guam that goes to arbitration. Every other type of case goes to regular arbitration, and in regular arbitration, the parties decide how many arbitrators there will be, what we will pay them. Will they be doctors or lawyers or both, or members of the community? But right now, they're mandated to fund 3 arbitrators, 1 lawyer, 1 doctor, 1 community member, and that's very, very, very expensive. So this allows them arbitration at a rate that they can afford, or that they agree to, on the terms that they agree to. And this is how negligence claims are handled in arbitration for every other type of case. So that's one. We continue to allow arbitration. The second thing is we have not changed the standard of care. It's exactly the same. And the third thing is that we are allowing, if they cannot agree to the type of arbitration, we allow for a backup, and that is you can go to a magistrate, which is already funded by the government of Guam. It's not going to take any more money from taxpayers to fund this. Like, some of the doctors have proposed that we all out fund their arbitration, the $50,000 per case, that we, the government, fund that to give them these special protections. And I think it's much more affordable that we fund a magistrate to act as the screening panel. So we allow the cases to be screened, and we're allowing these cases to be screened like no other cases are screened on Guam. It's a very special protection. It's confidential. They're going to screen for frivolous cases. Frivolous lawsuits are going to be told by that magistrate straight up that this is frivolous. You are not going to win, or we don't recommend that you get anything. And so I think that should be a deterrent to frivolous lawsuits. It's going to help to protect doctors, and it's going to protect their reputations by keeping this confidential until the screening panels come to that decision that, they were at fault or they were not. And we're talking about negligence here. We're not talking about, bad outcomes for patients. We're talking about, you have to prove negligence. You have to prove that you did not practice standard of care. That's who's liable today. That's who will be liable tomorrow. Only those people, not just because, the outcome was bad on my case, or, when I went to the doctor. I don't get to claim for that. I only can claim if they didn't do what they said they were going to do, which is operate on the right arm, and they operated on something else, negligence. It's where they've acted outside of the standard of care for Guam. And so I think this protects doctors. It allows access to justice for patients that right now, and these are the facts, they do not have access to justice. They are absolutely excluded by having to come up with a $10,000 filing fee, and $50,000 arbitration costs, expert witness fees, not including, if they proceed beyond arbitration to trial, they do it all over again. They pay, again, $50,000 for experts, for,
Yeah, Madam Speaker, I don't know if your sleeve is brushing the microphone there or something.
Oh, I'm sorry.
This reminds me of my grandfather. So he had an operation at Naval Hospital, and they sewed up one of the instruments up inside of him. Then they had to open them up again and take it out. But grew up poor. We don't have $40,000 to $60,000 lying around to pursue justice. So I wanted to talk about, because there's something I saw in the language, the number of complaints that have been successfully filed with this costly process that we're currently living under now. What's that number over the last, however many years?
I don't have it in front of me, but the numbers are so low. I want to say 7 over the past several years, right? So when we did the bill, we estimated 7 maximum cases that might be filed in a year. And that was based on years of what we could have, see. And we can't see, this is one of the things, to be, that maybe everybody needs to understand. This arbitration process does not allow us to see which doctors they're filing claims against. It does not allow us to see who's paying out, what they're paying out. It doesn't allow us to see any of that. We are not able to assess that. We are assessing it based on what was provided to us at the 3 informational briefings that we had. And based on that, these claims are very, very rare, maybe 2 a year. Yeah, and so we, thought 2 a year that can be handled with the current caseload of magistrates. And don't forget, magistrates, these are people appointed by the Chief Justice of the Supreme Court to act like judges. They're under the same code of ethics as judges and sworn to the same, not to have conflicts of interest and to be impartial in their determinations. And no, they're not doctors. And so doctors feel very uncomfortable that a decision will be made by somebody who's not a doctor. Well, this process continues to allow, just like the current arbitration process, where in this current arbitration, not all the panelists are doctors either. The panelist is 1 lawyer, 1 doctor, and 1 community member. So in order to inform the community members and the lawyers as to what the standard of care is on Guam, expert witnesses are brought in arbitration, and those cost at least $5,000 each. And this is not reimbursable. You're going to pay this no matter what. You bring in expert witnesses to say what you believe the standard of care is on Guam. And that's where really the debate happens. It's between the 2 expert witnesses on both sides as to what is the standard of care on Guam. That is going to happen in arbitration. That is what's going to happen under a magistrate. So the magistrate is not going to be uninformed. He's going to be informed to the fullest extent of the party's ability as to what the standard of care is on Guam. And there's nothing to prevent, anyone from bringing in doctors as expert witnesses. And in fact, that's how malpractice cases are done. And by expert witnesses testimony pretty much is, it's very crucial, but it's all paid by the person bringing the case. So I'm only addressing one part of the costs, and that is getting rid of this mandatory filing fees, mandatory 3-person arbitration, allowing for, arbitration at a level that you can afford or you agree to, or that somebody else is going to pay for, or a magistrate judge appointed by the Supreme Court, confirmed by the legislature in public hearings, so the public will also have input, and that these magistrates will, do what judges do, and that is make a determination based on the law and the evidence in front of them, and that parties will be able to, provide their argument as to what the standard of care is on Guam. So, I know that there's a lot of fear, it seems like, out there. The doctors are afraid that we are taking away their protection, but I hope that they will tune into these informational briefings and the public hearing, provide testimony, on July 7th, July 12th. I welcome all testimony and I welcome all suggestions. And we have received some very good suggestions, in fact, from some of the letters that we've received so far, some of the phone calls. I've had many talks with doctors and, so I think sometimes they're getting their information. I'm not sure from where, but I hope that they can get it directly from, our hearings on the bill, and that everybody can be informed before they really come down with a final opinion on this, and that we can improve this bill. I absolutely am open to that. And so That's why I'm having 3 hearings.
Right,
And I'm
yeah.
hoping that we are going to get suggestions and not just criticism, that we are going to be able to improve it. And that we're not going to back off from our commitment to those people who are being shut out of justice. I think that's just, it can't be right in anybody's book. It wasn't right even in the doctor's book that came before us in the last hearings. And so, I think we're going to take care of that.
Yeah.
We're not going to throw doctors under the bus. We are not doing any of that. We recognize and we are giving doctors special protections under Guam law that not all jurisdictions give, and that we on Guam do not give to any other profession. And so I just think that also needs to be very, very clear, and that I'm willing to work with all of them.
Well, we keep talking about the doctors. Let's get into their side of it. So I'm sure Dr. Shea was kind of the first one to clap back, and he said something like, I'm not going to work on certain type of cancer patients, which was a hard hit. And then we now have this letter that Senator Moylan was able to provide and is also circulating, signed by a bunch of pediatricians, Madam Speaker. 1, 2, 3. There's like about under 20 pediatricians. And I'm just going to read a little bit from here, and then we could get your response. As a direct consequence of this proposed Bill 11236, the practice of medicine is changing, and for the worse. Dr. Erica Alford, our island's adult endocrinologist, who has been generously willing to care for pediatric patients when we have needed her help both in the hospital and outpatient setting, has already stopped accepting pediatric consultations and will no longer be seeing any new or existing pediatric patients. This leaves children on Guam with diabetes and other endocrinologic disorders without a specialist to manage their condition. It's only a matter of time before other adult specialists do the same and start refusing to see pediatric patients as a result of Bill 11236. Moreover, we primary care physicians would not be able to manage our patients' complex illnesses either, for fear of litigation and the risks associated with practicing beyond our scope of training as general pediatricians. Our patients and their families will be left with no other option than to seek specialty care off island. This letter signed by Amanda Del Rosario, a pediatrician with American Medical Center and the pediatric department chair of the Guam Memorial Hospital.
Thank you for bringing that up, Chris. And again, like I tried to explain earlier, I think there's a lot of fear going around in the community. I think they are getting interpretations, and I'm not clear what those interpretations are that they're looking at, but I think it's a misconception to say that what they are practicing today is going to change or should change as part or in response to this bill. If they are practicing within the standard of care for Guam today, they will be practicing within the standard of care tomorrow pursuant to this bill, because it's the exact same standard of care that is copied from the current law into this bill. And we are not changing that. And the fact that, physicians are threatening not to see patients, that's a whole other realm of actions that I can't fathom. They are threatening because a bill is introduced, first of all, not even passed, to not see patients. I don't understand that. And if the standard of care is not changing, then their threats that they're going to not take care of the patients that they're taking care of today. I don't know where that comes from. It can't be coming even from a change in the standard of care. We're not requiring them to do any different standard of care. And I certainly hope that what they're providing today is within the standard of care. That's what it has to be. And I don't think anyone in the original malpractice, mandatory arbitration law was intending that physicians would be protected from negligence, protected from malpractice. That was not the intent of the law. It's not a blanket protection. It's a protection that if you perform standard of care, then we are going to protect you from frivolous claims that don't even allege that you violated the standard of care. And we want you to practice standard of care, and standard of care on Guam is different than standard of care anywhere else. It's based on what we have available to us. And if physicians are currently practicing standard of care, then they will be covered just the same under the new law because we are incorporating the exact same standard of care. And if we are, I was told, there's a lot of threats. There are threats. I think even some of the senators are fearing that their families are not going to be treated by these doctors because the doctors are making threats. That, I've even heard threats, would you believe this, that they're going to, that they will not treat poor clients because now the poor clients can sue, right? Because that's really the change we're making here, is we're opening it up that not only rich VIP clients or patients can seek justice for negligence, we're opening it up so that poor patients can also try to seek justice. There's still a huge cost, and I don't think we're going to be able to cover everybody, but we're opening it up a little bit more so that more people who really have been injured by malpractice, by negligence, that they are going to have some kind of access to justice. Really, it's that's the only change we're making. We're not changing standard of care on Guam. We're not changing who can consult with who, and we're not telling doctors how to practice, what they have been doing. And if they're changing, the logic of that is, especially prior to a bill being passed, if they're saying it's because of the bill is baffling to me. And if they're changing their practice because while we are keeping the same standard of care, then maybe I don't know. They should always be examining their standard of care. And we want standard of care. That's what we want for the patients. We want that for all patients. And we want access to justice. So I just think, I'm hoping that these pediatricians and all the doctors will take heed of, the information provided during the hearings, that they will listen to other testimony. We've also received testimony from other doctors. And I agree with a lot of their suggestions. They continue, and we as a legislature have a lot of work cut out for us to address medical care on Guam in general. We need to retain and recruit doctors by increasing salaries, especially at GMH. We've had oversight hearings to address salaries at GMH for doctors and professional staff, including nurses. We have had hearings at the University of Guam as to how we are going to fund local people to fill these fields, right, so that we will get these doctors to come back to Guam. Doctors are committed and are not going to abandon patients, who are going to serve these patients of Guam, just like we all, are trying to do out of love for the people of Guam, and to do that to the best of our ability. And I think we as a government are continuing to take, to offer protections not afforded everywhere, that we're trying to offer protections and we're trying to offer support. And there's a lot of work to be done. This bill does not solve at all half of the crises in the medical centers, but we have been working diligently to address those. There's things like preventative care that we absolutely have to support public health in their efforts, on diabetes and preventative care. And before these become huge issues and sometimes irreparable harm to the patients.
Yeah.
So,
Madam Speaker, I just have one more question. I'm sorry, but just on this current issue that we're talking about. So you're saying the existing law was not designed or was designed to protect doctors against frivolous claims, but the way it ended up happening because of the expensive and, clearly poor people can't afford to bring anything. So it kind of seems like it's protecting doctors from all claims now if they're only getting 2 a year.
Absolutely. And I think the doctors recognize that, at least the ones who, I've received letters from, many of them recognize this. It's not a secret. That is well known, that they are absolutely protected from any claims right now, from people who cannot afford a $10,000 filing fee, people who cannot afford to hire, an expert witness at $5,000, who cannot afford the approximately $50,000 of arbitration costs prior to going to trial.
Right.
And you know that in all other negligence cases, they go straight to trial. Every other person who harms another person, we can take those straight straight to trial. And so this is very special. And there's a policy behind this special treatment of doctors that I recognize and I want to affirm. But I just think we cannot, in affirming that policy, block off poor people from accessing justice. Even the district court recognizes that, and they want it to hear from the Supreme Court as to, what do we do with the poor people who can't afford arbitration? And so I hope everyone will just tune in, keep their minds open, and not succumb to fear. Of course, I wouldn't be pushing this bill. I have a family who needs medical care. Who doesn't, right? But we also have a community who needs access to justice. And I think there is a way to balance both. And I think fear shouldn't be part of it. Open discussion should be really the way, and that suggestions and ways to make it better, I'm very open to that. But otherwise, I'm not going to succumb to fear, and I hope that these doctors do not. And I think that there is absolutely a way for GMH to contract and hire specialists, and have them avail of liability protection at GMH. I mean, all of that, it's still intact. There's nothing that changes any of that.
Speaker, this question from Nestor. For the first time this fiscal year, the latest CRER shows revenues collected are more than $6 million more than projected. What's your reaction to that?
That was startling news for us. Good news, I guess. It's we asked the Director of Revenue and Taxation if she could explain where that surplus came from, or the excess. She really didn't have a good answer on that. I was asking whether it might have been from the tax refunds that they extended the deadline until May. So those were just paid, right? Some of those, the tax returns. So some of those taxes were paid probably in May, and maybe that accounts for the bump. But otherwise, we haven't got a full explanation of that, but that's good news. So I hope our economy is beginning to recover a little bit, and but we still see shortfalls in the special funds, huge shortfalls in many of the special fund areas. And so it's not a overall, excess for the government of Guam, but it was a rise in the general fund.
All right. Thank you, Madam Speaker, for your generosity
so
with your time. Yeah, appreciate it.
And again, the hearings are at 5 o'clock today on this medical malpractice law. 5 o'clock today, 5 o'clock on July 7th, and 5 o'clock on July 12th. Thank you again.
Okay. There you go, Speaker Therese Terlaje. Interesting. It's so interesting to me. You know what I mean? That I got a friend here. This is just a personal story. I'm not going to name where, but anyway, so my friend's father-in-law is currently hospitalized, and the nurse gave my friend's father-in-law the wrong IV. Like, it was the IV for the patient next door, and they gave that's not even funny, sorry. Gave the father-in-law the IV from the next door. And so this friend called me, and they were like, hey, they said that they're gonna they were going to like call the nurse in, and I don't know whatever happened with that. But so basically the place had confirmed that there was, a negligent act. And so he said, hey, can you know any lawyers who would want to just talk to us to see what, if there's anything we can do